Rule 1.2 is an absolutely crucial rule to know, especially 1.2a. I would encourage you to watch this video to the end because I think the concepts in this rule are a relatively frequent source of discipline and malpractice cases or fee disputes. Before we talk about Rule 1.2, we have to briefly address a few other rules because 1.2 refers to them. I will talk about these other rules in detail in other videos, but here are the bullet points. First, Rule 1.2.1 prohibits advising or assisting a client to engage in criminal or fraudulent behavior. Rule 1.4 requires a lawyer to communicate with their clients and reasonably consult with the client about the means by which to accomplish the client's objectives. Remember that point. It's going to be important later in this video. The last concept referenced in Rule 1.2 is confidentiality, as laid out in both Business and Professions Code 6068E1 and Rule 1.6. So with that foundation in mind, let's talk about Rule 1.2. And don't forget to subscribe. I'm going to focus this video on Rule 1.2a because 1.2b is self-explanatory. But before I do, let me at least summarize 1.2b. Rule 1.2b allows a lawyer to limit the scope of the representation if that's possible under the circumstances, not otherwise prohibited by law, and the client gives informed consent. I explained what informed consent means in my video to Rule 1.0.1. Here's the important part that applies here. The terms informed consent or informed written consent are important because you might think that you have received informed consent from a client, but the definition is specific about two crucial items that you must explain. First, the relevant circumstances, and second, the material risks, including any actual and reasonably foreseeable adverse consequences of the proposed course of conduct. The comments to Rule 1.2b make it clear that there are other rules and laws regarding limiting the scope of representation. So make sure you look at Rules 1.1, 1.8.1, and 5.6, as well as the California Rules of Court and other local rules of court before you agree to limit the scope of representation. Now let's talk about Rule 1.2a, which should really have been broken out into multiple subsections because it has 4 different requirements. First, it says that subject to Rule 1.2.1, no criminal or fraudulent behavior, a lawyer shall abide by a client's decisions concerning the objectives of representation and, as required by Rule 1.4, which is communication about the means, shall reasonably consult with the client as to the means by which those objectives are to be pursued. Second, subject to Business and Professions Code 6068E1 and Rule 1.6, a lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. Third, a lawyer shall abide by a client's decision whether to settle a matter. And fourth, except as otherwise provided by law in a criminal case, the lawyer shall abide by the client's decision as to whether to enter a plea, waive a jury trial, and whether the client will testify. You can see why this is where lawyers might run into trouble. If you have a client that wants you to take ill-advised action, you have to fully engage in that discussion. And as the comments make clear, A lawyer is authorized to act on behalf of the client in procedural matters and in making certain tactical decisions, but may not impair the client's substantive rights or the client's claim. And although the comments point out that a lawyer may get advanced authorization to take specific action without further consultation, the client can revoke that authorization at any time. So these duties are frequently in tension. Often there will be a disagreement regarding tactical decisions, and the client might feel like if the lawyer is not following the client's directions, then the client's substantive claims will be impaired. Even if the client's substantive claims are not actually implicated, this could still lead to a malpractice lawsuit or a fee dispute. Yes, you might win, but obviously it's best to avoid that problem. But if the substantive claims are implicated, then it could lead to discipline. So the lawyer is stuck pursuing a course of action that could end up actually hurting the client and getting bad results because of the lawyer's ethical duty imposed by this rule. Since this course of action is at the express direction of the client, it avoids any discipline problems, but it might make the case more expensive or lead to a bad outcome, so it increases the chances of a malpractice lawsuit or a fee dispute. So what can you do? Well, there's no perfect solution to this problem. But if you, as the lawyer, act in a professional manner and have open and honest communications with your clients, then you will increase the chances that your clients trust you and take your advice. Don't forget that being a good lawyer is not just about the arguments you make in court or how you deal with opposing counsel. A very large part is the lawyer-client relationship and your ability to work with your client. You're not there to just take direction as a hired gun, and you are also not a lone wolf. You should think about any representation as a joint undertaking.